Welcome back. Now we examine 3 cases involving federal criminal substantive and procedural law. We begin with an issue of criminal procedure. In United States v. Tinklenberg, the court held the running of the 70-day Speedy Trial Act for bringing a criminal case to trial stops once a pretrial motion is filed and doesn't start running again until that motion is decided. The Act expressly excludes from the 70-day period, quote, delay resulting from any pretrial motion, from the filing of the motion through the conclusion of the hearing on or other prompt disposition of such motion, close quote. The question before the court was whether a motion that was not expected to delay the trial beyond the 70-day period nevertheless stopped the clock, or whether the exclusion applied only to those motions that were expected to delay the trial. The court held that it didn't matter what was expected. The clock stops when the motion is filed, and that rule applies to all pretrial motions. It's what the rule says, that's the way the court applied it. Next, we turn to the proper interpretation of the federal witness tampering statute. In Fowler v. United States, the court held that a violation of the federal witness tampering statute occurs when someone kills another to prevent likely communication with federal law enforcement officers relating to the commission of a federal offense. The government does not have to show a specific intent to communicate with a specific federal officer, but there must be more than a remote possibility that communication with some federal law enforcement officer would have occurred but for the killing. In particular, where a defendant kills a person with an intent to prevent that person from communicating with law enforcement officers in general, but the defendant did not have federal law enforcement officers particularly in mind, the government must show that there was, quote, a reasonable likelihood, close quote, that a relevant communication would have been made to a federal officer. That's what provides the nexus to federal jurisdiction, and if that's absent, the federal crime doesn't exist. Our last straight criminal law case involved an indictment for distribution of 50 grams or more of cocaine base under Section 841A1 and B1A3 of Title 21. The question was whether there was a statutory difference between crack cocaine, for which sentences are longer, and cocaine base. To resolve this, the Supreme Court dove into the chemistry lab with its decision in DePierre v. United States. The precise issue was whether Congress, when it used the phrase cocaine base in its criminal drug laws, meant to refer only to what colloquially is known as crack cocaine, or whether it meant to refer more generically to cocaine in its chemically basic form, which to a chemist means C17H21NO4. Noting that Congress did not refer anywhere in the statutory language to crack cocaine, the court concluded Congress intended simply to distinguish between 2 different chemical forms of cocaine. Cocaine base, which has the chemical formula I read above, and cocaine powder, which actually has a different chemical name, cocaine hydrochloride, and a different chemical composition. The issue is important because the penalties associated with cocaine base are much heavier than the penalties associated with cocaine powder. According to the court's interpretation, cocaine base encompasses more than just crack cocaine. It also includes coca paste and freebase. Well, that's it for our general criminal law cases. To continue, click on the Constitutional and Civil Rights link in the Supreme Court Review table of contents.